Buenas tardes. Quiero empezar esta última.
Good evening. I'd like to begin this last session of the day, an intense and interesting day, thanks to all the people who have spoken here, who are accompanying us, who came here just for being with us today and tomorrow. It seems that those who came from far away, the Philippines, United Kingdom, Strasbourg, Armenia, but our colleague coming from Madrid is not here. So let's begin. Is she here? Is Celsa here? I didn't see her. She was here a while ago. Okay, let's begin anyway. She can join us later. On my right, there is Fernando de la Fuente, a colleague in Court of Violence Against Women. They are the rapporteur. He is the rapporteur that will help us to determine the findings of this Congress. Normally, we talk about criminal, civil, labor jurisdiction, family jurisdiction, but not very often on contentious administrative jurisdiction. We may think that it is more tailor-made for men than for women. This jurisdiction is very important. Law interpretation here is tailor-made for men, as I said, so we need more women to interpret rules, and even more in countries where, when a law is created that has to be respected, we need a gender impact report before passing the law. The role of those gender impact reports is ignored normally. That's why it's important to integrate this gender perspective when talking about administrative justice. Our panelists today have a great experience, so if you want, let's begin with, as Celsa's not here yet. Yeah. Ah, you're there. Hi, Celsa. She came just on time. So let's begin with Celsa. She was one of the first women in the judicial power, because in Spain until year 77 we were banned to enter in the judicial system. Since 15 years ago she is a magistrate in the Supreme Court. You have the floor. 12 minutes.
Bien, buenas tardes. Saludo a todo el mundo y así ya, diríamos, se avanza.
Good evening to you all. We've already mentioned the importance of gender impact reports. This was established in a legal reform more than 15 years ago, but during the coffee break I was saying that we had to wait until last Monday to develop the precept of our Equality Organic Law of 2007, creating in the whole public administration of this state equality units. They will have an important task, as the staff will be trained in gender issues. So this is an example that shows the great difference existing between the wording of the regulations and put in practice. As Mar said, women were banned in Spain to be present in the judicial system, and this is another legal normative that certifies the social problem between regulations and the fact that concerned people accept the possibilities that we may have at our hand. This reform took place in 1966. And in the first 15 years, only 2 women wanted to enter the judicial system. It was in the 80s when women joined the judicial system in a more, let's say, natural way. To me, it's a proof of the difference between the law and society. And even women concerned. That's why I like to underline the importance of adding to the legal culture this principle of equality. Because with that, it will be easier to use this gender perspective, to make use of it. The contentious administrative jurisdiction controls in Spain different activities. In other legal systems, some of these activities are taken by the civil jurisdiction. This is defined in the organic law of equality. There are different issues that highlight the importance of gender perspective in different domains, in larger domains. There was also a legal reform in Spain 3 years ago, the contentious jurisdiction law, that changed the access to cassation and now there is a list of suppositions when we understand there is an objective cassation interest and the court can admit those suggestions or not. This has allowed that in the Supreme Court there are some issues that still are to be decided with very relevant gender perspective issues. For instance, one university in Madrid grants more points to women in certain circumstances when there is a seat available for a professor. If there is a vacant, another problem which is still to be decided, which is very relevant nowadays, given the higher presence of women in many groups, is the appointment of committees for selection processes. The equality law states that there should be a parity composition, 40, 50, 60%. This has been done, but as some people renounce, substitutes can enter in the committee, and there was a case, an example where a whole committee was made of women. Someone denounced that, and it was cancelled. The public exam was cancelled because of that. So a law conceived to be in favor of women finally turns against them. We also have the problem of not taking into account the fact of having a maternity leave. This is not taken into account regarding seniority in certain public exams. If you had a maternity leave, normally this was for the woman and not the man. So if this is taken into account this way, this is a discrimination for gender reasons. We also have to talk about gender impact reports drafted by the governments in all regulations. They have to do that for all regulations, even for legal projects. We can't control only regulations, but it's important to say that some years ago, a group of women contested a draft bill of budget because there was no gender impact report. The contentious administrative justice said it was not of its competence, but it was relevant, as it was a wake-up call for the administrations regarding the need to draft that gender impact report. And now, every year, we see that published, posted on the website of the Parliament. So it is made together with the national budget law. Budgets can have an impact on gender. If you're not familiar with contentious administrative jurisdiction and budgets, this is something which has been mentioned very much by the European Union. In Spain, the VAT rate was decreased, and in different other countries. United Kingdom, VAT rate is high for tampons, for female products. The VAT rate was like a luxury product, 21% here in Spain. So this has an impact on gender, because tampons and other elements, are made by women, and there's a survey done by the European Union, approved by the Parliament, that underlined the difficulty by many teenagers and women to have access to these articles because they were more expensive. So this is also discrimination. So this gender impact report on regulations is important. It's useful for saying if there's a negative or positive impact. Normally these reports say that there's no impact at all, no positive or negative. But normally parties, when they contest a regulation with a deficient gender impact report, they don't normally, or at least until the present, only in very few cases, they have not required the nullity of that report due to deficiencies. Our regulation says that it's not enough by saying that with the proposal there are not essential impacts. That's not enough, as I say. We had some decisions, some judgments where gender perspective was analyzed in urban planning matters, and for that we have very clear the regulations by the European Union that says that gender has an impact on transportation issues. Some urban plans have been cancelled due to that. We are not, in Spain, we are not federal states, but we have autonomous communities with competencies. Regulation is not the same in the whole country. In Andalusia, the plan was cancelled by the Supreme Court because the regulation said so. But in Madrid, one plan that was cancelled, it was considered that a gender impact report was not necessary because no regulation required it. Regarding asylum, there were some judgments that considered important this gender issue. Genital mutilation for women, forced marriage, and public bidding. There's a regulation which is applicable throughout the country, the equality law. In public contracts and bids, in equal conditions, in case of equal conditions, the tie-break will be decided with those companies who hire more women. There was a judgment in the Supreme Court, and it was resolved. And as I'm running out of time, to finish, I'd like to say that even if you may be aware of this issue, on the criminal jurisdiction, it's also been very relevant in the contentious administrative jurisdiction. The drafting of a CEDAW report to claim responsibility of the state due to the abnormal functioning of the justice administration. This is to say that a woman whose husband, the husband of the wife, killed their children. And she claimed to have reported that in many occasions regarding the visit regime and regarding the behavior of the husband. And it was considered that the Spanish state, no measures had been taken to protect the children. So she appealed to the Ministry of Justice demanding responsibility. It was denied, and then the Supreme Court understood that fundamental rights of the claimant had been ignored, and it was a little case. It was a strategic lawsuit, and it's very significant due to the change of this CEDAW convention. They are not binding, but for the Spanish state, this was considered as a determining element for taking action. I have no more time, so that's all. Thank you very much.
Bien, vemos la importancia, ya empezamos a vislumbrar la importancia.
Good, so we're beginning to see the importance of the contentious administrative jurisdiction with the gender perspective. Next, we're going to hear from the Magistrate Julia Murdoch from the European Court of Human Rights. She was in the Constitutional Court of Romania, and since 2013 she has been working in the European Human Rights Court. It's an honor to have her here. She's going to talk to us about the importance of the Istanbul Convention. Thank you very much.
to be invited today to this association. And I was talking to the colleagues and almost friends that I met here, and I was thinking that we have to create an association of international judges. We are not a lot of international judges, women, unfortunately, but I think it's something that is necessary, and what I have seen today was very much an inspiration for me. So today I am going to speak not about something which is directly related to the administrative law, but I'm going to speak about the equality and violence against women in the case law of the European Court of Human Rights. The European Court of Human Rights has dealt with many cases of violence against women over the past decades. The aim of this presentation is to analyze the evolution of the Court's case law on violence against women in light of international law developments. It specifically examines the European Court of Human Rights law prior to the following the adoption of the Istanbul Convention in 2011. From a traditional approach to the European Court of Human Rights violation under Article 2, 3, and 8, the Court has progressively recognized the specificity of this type of violence, including its discriminatory character toward women. Violence against women can take many shapes and forms. Cases of police violence, rape and sexual abuse, female genital mutilation, and domestic violence has been brought before the European Court on Human Rights. The Council of Europe Convention on Preventing and Combating Violence Against Women, what they have to do with it? I know, sorry. One?
Yes, this? It's okay?
It's okay.
Right.
Yeah. Right, yeah. So the Council of Europe Convention on Preventing and Combating Violence Against Women and Domestic Violence, Istanbul Conventions, defines violence against women as gender-based violence likely to result in physical, sexual, psychological, or economic harm or suffering to women, whether occurring in public or private life. This presentation aimed to analyze what happened before the adoption of the Convention in 2011 and after the adoption of the Convention in 2011. So the case law sorry, I think I was, yeah. It's the vice versa, sorry. I'm not used. Okay. So the case law prior to the Istanbul Convention. When it comes to violence against women, the court traditionally applied the following provisions: Article 2, right to life; Article 3, prohibition of torture; and Article 8, right to respect for private and family life. Article 2 of the Convention yields both negative and positive obligation. Not only must the state parties refrain for taking one life, but also they are under the obligation to take all the necessary steps to prevent death resulting for the acts of the third parties, providing that a real and immediate risk to the life of the individual is known or ought to have been known by the authorities. In Branko Tomasic and other versus Croatia, the Croatian authorities failed to take appropriate steps to prevent the death of a child and his mother. In particular, the authorities knew of a serious threat met the life of the mother and the child and failed to act accordingly. Additionally, Article 2 of the Convention imposes the procedural obligation to have in place an effective, independent judicial system capable of establishing the facts and holding those of fault accountable. In Dermos versus Turkey, the court held that Article 2 had been violated under its procedural limb because the Turkish authorities had failed to effectively investigate their daughter's death. Under Article 3 of the Convention, ill treatment needs to reach a minimum threshold of severity. The assessment of this minimum level of severity depends on the circumstances of the case, such the nature and the context of the treatment, its duration, physical and mental effects, and in some instances, the sex, age, and state of health of the victim. In P&S versus Poland, the court found that the suffering of the first applicant, raped and pregnant at age 14, and the deplorable manner in which the authorities had treated her met the threshold of severity under Article 3. Additionally, Article 3 stipulates a procedural obligation to conduct an effective investigation capable of identifying and punishing those responsible of these acts. In the case of Maslova and Nabaldov versus Russia, concerning the rape of a detainee by a state official, the court found a violation of Article 3 under its procedural limb on account of the lack of effective investigation. Under Article 8 of the Convention, state parties have a duty to protect the physical and moral integrity of an individual for other persons. In domestic violence cases, the court finds a violation of Article 8, particularly when the state authorities knew of the risk of violence and failed to enforce protection measures designed to protect the victims. In the case of A versus Croatia, Croatian authorities failed to implement measures ordered by the court to protect the applicant and address her ex-husband's psychiatric problems. The court has also stressed that the authorities cannot justify Article 8 violation because they consider the matter to be private. Respecting the right to private life does not prevail over the duty to protect individuals for violence of the third party. A very important case of our court is the case Opus versus Turkey. The 2009 case represents a turning point for the issue of violence against women in the court's case law for two reasons. First, it extends the application of Article 3 to cases of domestic violence, and second, it finds a violation of Article 14 of the Prohibition of Discrimination. The facts of the case are the follows. The applicant and her mother had both suffered for violent and life-threatening assault by the applicant's husband over many years. The court found a violation of Article 3 due to the state failure to protect the applicant. It found that Turkey did not establish and apply a system for punishing and protecting victims against domestic violence. The state party must indeed take all necessary measures to protect the victim for such violence. In the case AS and other versus Slovakia, the court found that Slovakia had failed to provide the first applicant and her children with an immediate protection required against her husband's violence. The court has also, for the first time in a domestic violence case, found that there had been a violation of Article 14 in conjunction with Article 2 and 3 of the Convention. In this case, the court observed that the manner in which women are treated in the police station by the authorities shows the general and discriminatory judicial passivity in Turkey. The domestic violence suffered by the women in this case were therefore gender-based and discriminatory towards women. Similarly, in cases of Armenia and other versus the Republic of Moldova, regarding the violent abusive behavior of a husband and father, the court found a violation of Article 14 in conjunction with Article 3. It found that authorities had not only failed or delayed dealing with the violence in question, but they also repeatedly ignored in which amount of discrimination against the applicant as a woman. The court's traditional approach to the case of violence against women fails to appreciate the specificity of the issue, such a discriminatory character. The absence of the instrument which specifically deals with the issue results in a general and somewhat imprecise application of the Convention to cases of violence against women. Together with Opus case that I explained, the progressive changes after the adoption of the Istanbul Convention. The Convention of Preventing and Combating Violence Against Women and Domestic Violence, the Istanbul Convention, is a legally binding instrument which was adopted in 2011 and entered into force in 2014. It has been ratified by 27 states, including the European Union. The aim of the convention is to protect women against all forms of violence through prevention, protection, prosecution, and implementation of integrated policies. In its definition of violence against women, the conventions establish two key principles. Violence against women is a violation of human rights. Second, violence against women is a form of discrimination against women. Recognizes violence against women as a human rights violation means that state party to the Istanbul Convention now have to due diligence obligation to prevent, investigate, punish, and provide reparation for such acts. The Istanbul Convention in the case law of the court. While the court does not apply the Istanbul Convention, it may nevertheless utilize sources of international law when interpreting the European Court of Human Rights in the light of the objective and purpose. The court refers to the Istanbul Convention were shy at first in case where states that have not yet ratified. For instance, in the case Y versus Slovenia, concerning a young woman rape complaint, the court cited the Istanbul Convention but stressed the fact that Slovenia was not a part of the convention. It analyzed the case under Article 3 and 8 of the convention, excluding the analysis of the Article 14. Later cases do reference to Istanbul Convention, taking into account the discriminatory nature of violence against women. Cases against Turkey as MG versus Turkey, Halime Kilic versus Turkey, and Çivek versus Turkey all analyzes the violation of Article 14 of the European Convention of Human Rights. In the case Halime Kilic versus Turkey, the court found a violation of Article 14 in conjunction with Article 2 because the authorities failed to protect the victim from repeated acts of violence and death threat made against them. The court case law, to conclude, I have something else to say, but maybe in the dialogue. The case law of the court on violence against women has evolved over the past decades. From a traditional approach to the convention violation under Article 2, 3, and 8, the court has progressively recognized, first with the Opus case, the discrimination which women are subject to when reporting acts of violence to the local authorities. Recently, to the first to apply Article 14 of Prohibition on Discrimination, the Istanbul Convention gave the court the necessary impulsion to take a further and stronger stance into the issues. Thank you very much.
Muchas gracias también, magistrada.
Thank you very much. Following on, we shall hear from a magistrate who comes from the United Kingdom.
Can I have my PowerPoint? Yes.
Okay. Si es, viene desde...
She's from England, well, the United Kingdom. She's a magistrate in the Migration and Asylum Chamber in the Superior Court. This is an important area in which there is an important gender perspective in the delivery of justice, so I give you the floor.
It's an absolute privilege to be here today. You're all very patient to still be awake so late in the afternoon. But this is a really important Am I doing it wrong? I'm doing it wrong. There we are. Is that any better? Yes? I can see people nodding. So it's a privilege to be here. Thank you very much for letting me come. Now, I want to talk about how hard it has been to get anything resembling a gender balance for women judges in the United Kingdom. You have to remember that in the 1800s, women had no civil rights at all. They were chattels. Their money went from their father to their husband. They were treated in law as though they were their children's parent, though I don't quite see who else's parent it would have been, but there we are. So I want to look just at some of the international principles, if I can work out how this goes. I'm just pressing buttons at random. That one didn't. Ah.
The right one.
Ah, yes, got it. So, the basic principles on the independence of the judiciary from the United Nations, 1985. In the selection of judges, there shall be no discrimination against a person on the grounds of race, colour, sex, religion, blah, 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 property, birth or status, except that a requirement that a candidate for judicial office must be a national of the country concerned shall not be considered discriminatory. European Charter on the Statute of Judges, which has no force in law but has advisory force, 1998. The statute excludes any candidate being ruled out by reason only of their sex or ethnic or social origin, or by reason of their philosophical and political opinions or religious convictions. And the European Network of Councils for the Judiciary report on the development of minimum judicial standards, 2011 to 2012. Diversity should be encouraged, avoiding all kinds of discrimination. That doesn't necessarily imply the setting of quotas per se. Any attempt to achieve diversity in the selection and appointment of judges should not be made at the expense of the basic criterion of merit. The entire appointment process must be open to public scrutiny. This is the important part, since the public has a right to know how its judges are selected. In 1918, women in the United Kingdom partly got the vote. To be fair, men only partly had the vote at that point. Women over 30, women with property, women with a stake in the country. 1919, they very kindly stopped disqualifying us from holding civil or judicial offices or posts. Before that, you couldn't. It's still for us a second career. You have to be a lawyer first. You have to be an advocate or something rather like a notary, a solicitor, or a legal academic for a while before you can ask to be a judge. So our judges become judges from a professional career elsewhere in law, and in their late 30s, early 40s. And as Lady Hale, who you all know, said recently, in fact on the 1st of January, which was the 10th anniversary of the setting up of our new Supreme Court and the 100th anniversary of women being allowed to be judges and lawyers and so on, she said there are several reasons for desiring a more diverse judiciary in terms of gender balance, ethnicity and social background. The most important of these is so the public can look at the judges and say they are our judges, rather than seeing them as beings from another planet. It's very important that the judges reflect the population they're judging. It gives confidence, it gives legitimacy, and that is why our struggle to get anywhere near equality has been so disappointing. By way of a side note, in 1977, when I was training to be a solicitor, I was in the first class in that college which had 50-50 men and women. They were so proud. I didn't think 40 years later we'd still be arguing about it. 40 years? Really? So, here's what it really is at the moment anyway. 1922, 3 years after the Act, the first woman barrister and solicitor qualified. Carrie Morrison was the solicitor, Ivy Williams was the barrister. 1923, I didn't put it on here, but a woman who had been writing opinions for other people for 34 years, with a law degree but no qualification because she wasn't allowed one, finally got the qualification. 1962, first woman county court judge. 1988, first woman in the Court of Appeal. 2004, first woman Lord of Appeal in Ordinary, Brenda Hale. 2009, first woman in the Supreme Court, Brenda Hale. There's a pattern developing here. 2017, first woman president of the Supreme Court, you got it, Brenda Hale. 2018, first all-women panel in the Supreme Court. That was October last year. Brenda Hale, Jill Black, Mary Arden. 2019, first woman president of the Queen's Bench Division of the High Court, Victoria Sharp. That's a long delay, isn't it? Here are some disappointing statistics. 1999, when I became a part-time judge, 3% of judges were women, 3% were solicitors. By 2015, it was up to 45%, but mostly on the sticky floor. By 2018, it was 46% and 41% of the upper tribunal. And for women judges under 60, more women than men, which I know reflects what happened in France, where the appointments are now 80 for young women judges. The younger judges are keener to apply, they are more open to applying. 2019, the number of upper tribunal judges for women is down to 35%, and it'll soon be down to 33%, and I'm going to tell you why. High Court, Court of Appeal, Supreme Court, all still about 25%. You know, we haven't even beaten Kenya. I mean, it's a bit sad, really, but there we are. Ruth Bader Ginsburg, the notorious RBG, is famous for saying, when she was asked when she would be satisfied with the number of women in the Supreme Court, she said there'll be enough when there are 9, which would be all the Supreme Court justices. And somebody said, really? And she said, well, there've been 9 men for hundreds of years, and nobody ever thought that was odd. So, more work to do still, very much. We're making progress, but it's slow, and there's a sticky floor, and women are reluctant to apply because women always think that they should apply when they meet the requirements perfectly. But the other problem we have with being a second career is if they get treated badly as barristers or solicitors when they're having their children, when their lives are developing, they leave the profession. And when you get to the 30s and 40s, they are not there to appoint to the judiciary. They've gone. The other problem we have is that many women in the judiciary in their 30s and 40s, because we are encouraged to wait to have our children, in my country anyway, they have teenagers, they have aging parents, they have huge practical difficulties to cope with. We do have the option in the tribunals, which is the administrative jurisdiction broadly, we do have the option to take percentage working. And I have lots of colleagues who work 50%, 60%, 70%, 80%. I've been 90% since 2007. Hasn't stopped me doing anything. But there's beginning to be a reaction. Our latest appointments round in my tribunal specified that for the reasons of the needs of the business, only those who could sit 100% should apply. You know what? When we said that we would accept percentages, we got 10 people, 9 of them were women. When we said we wanted 100%, we've got 9 people and 8 of them are men. And that's why our percentages are about to go down to 33%. So, it's disappointing, it's a struggle, it continues to be a struggle to get a reasonable balance reflecting the fact that after all, 50%, perhaps slightly more of the population is female. But it's better than it was. And the more examples we have and the further up the system we have them, the more a young woman will look at the judges and say, well, they look like me. I could do that. I'll apply. So it's progressive. But I still think that we are not as far along as we ought to be. I haven't got much time left. We've all talked about the Istanbul Convention, and that's the definition. This will all be in my paper, which will be available later. In my country, we signed the Istanbul Convention in 2012. We still haven't implemented it. In 2017, we passed a statute saying that we would have an annual report as to why we hadn't implemented it, which really isn't a lot of help. In January 2019, there was a draft bill. Yes, I'm sorry. But Brexit has, I promised I wasn't going to mention the B word. Brexit has crowded it out of the calendar. I don't think it's going to get parliamentary time. I don't know when we're going to sign up to the Istanbul Convention. We don't have a written constitution, so there's nowhere to bolt gender violence in properly. We have no overarching domestic violence provisions. I'm envious of your new domestic violence courts. I think that's great. What we do have is bits and pieces of gender protection in different bits of the administrative tribunal systems. In the immigration and asylum chamber, when we're talking about asylum, we're talking about female cutting, domestic violence, rape and so forth in the country of origin, and there is a provision if somebody comes to the United Kingdom as a spouse or a civil partner or a same-sex partner or an unmarried partner, and the relationship breaks down on gender violence grounds, that you can get leave to stay on that basis if the other person is British. It's very narrow. You have to have certain proofs, you have to do it within a certain time. It often doesn't work, but sometimes it does. And if you're there with a student or somebody who isn't settled, then you've got to use Article 8. The employment tribunals implement the Equality Act. We heard about that earlier. There's no need to say it again. We have an FGM Act, but we haven't had any successful prosecutions. We have a Forced Marriage Civil Protection Act, which comes under the criminal jurisdiction, not the administrative jurisdiction. That's working a bit. Not as well as I'd like, but better than you'd expect, perhaps. So, that's a bit of a canter. There is more to be said. Thank you for your attention, particularly this late in the day, and thank you very much for letting me come.
Muchas gracias, Magistrada Gleason.
Thank you very much, Magistrate Gleason. And now, Nora Karapetyan, she's a judge from the Civil Appeal Court from Armenia. Now we are moving away from the capital in Madrid to more faraway countries. She will tell us about the role of women in justice in Armenia.
And thank you to have great patience to stay with us. I will try to present you the situation and challenges of women in Armenia justice. Armenian women are always in attention of all the society. Their role is crucial in almost all spheres in life. You can't imagine legal professional life without Armenian women participation. Nowadays, you can't imagine the judicial power in Armenia without women judges who are very proactive, ambitious, and initiative. Judiciary is the most improved institution in the ratio of men and women. Gender equality must be embraced in order to achieve sustainable development. Women judges are role models to young women who are looking up them to lead the way. Armenian women judges, who also are lecturers, often hear that the girl students want to become as they are and are inspired by their example. The perception of women judges is more merciful than for men. But there are some problems concerning women in justice in Armenia, which we try to analyze during our presentation. Similar to many other countries, there are many stereotypes in Armenia concerning women's role in society and their ability to be a good leader. There are assumptions that women are children's primary caregivers and will stop working or reduce work levels if and when they become mothers. But it is important to realize that the whole point of the law is to require suppliers to treat each person as an individual, not as a member of a group. The individual should not be assumed to hold the characteristics which the supplier assigns with the group, whether or not most members of the group do indeed have such characteristics, a process sometimes referred to as stereotyping. To be a mother doesn't mean not to be able to work and think, to lead and to motivate. On 2018, in the report of Commissioner for Human Rights of the Council of Europe was mentioned that whereas women in Armenia enjoy equal access to education and obtain levels of education that are comparable and often even superior to those of men, women in Armenia continue to suffer from major inequalities in political, social, and economic life, as evidenced by several international rankings on gender equality and women's empowerment. In 2016, women accounted for only 23% of judges and 22% of constitutional court judges. The international organizations and documents underline the importance of judicial diversity and of ensuring women's full and equal participation in the judiciary. It was not that states are obliged under international law to guarantee women's ability in law and practice to participate fully in the judiciary. Though there is a provision in Judicial Code of Armenia for ascertaining 25% of each gender, the statistics show that the situation is not right now, and nothing promises to be better in this field. The candidates of judges are more men than women. In 2016, in the list of candidates of judges, there were 9 men and 7 women. In 2017, 6 men and 3 women. And in 2018, 10 men and 9 women. Though the laws demand that for every sex must be guaranteed minimum 25% places, it is a common rule and is not detailed by separate courts. In the result of this, the majority of women are concentrated in the general jurisdiction first instance courts. In the professional courts, even where direct legal, policy, or ideological barriers or restriction on women's full and equal participation in the judiciary doesn't exist, serious deficits of gender diversity persist. In bankruptcy court, only 1 of 12 judges is woman, and in administrative court, only 6 of 24 judges are women. In the last year, new candidates for appeal court are selected only men. 3 candidates for the cassation court submitted to the parliament were men. Considering the candidation of judges for cassation court, constitutional court, and chairman of cassation court, even no discussion took place about balance between men and women in these courts. The picture is very interesting in cassation court of Armenia. Only 4 of 17 judges are women, but chairmen of both chambers in Armenia are women. In the history of Armenian justice, no woman was a head of cassation, earlier Supreme Court. What about this decision-making body? Only 1 member in High Judicial Council is woman. There is quota for women during the elections from judiciary, but there is no such legal demand for members from scientific area. In the result, no women scientist member works in High Judicial Council now. And during the last election for a member from cassation court, there were 3 candidates. 1 was a woman, and 2 of them were men. After the elections, it was clear that each of men took almost 5 times more voices than the woman. But as an enforcement of the law, the woman might pass. The men complained that the procedure described by law is unfair, as they have much more voices. After this, the woman refused to be a member. The situation is not solved yet, and there is no member from Court of Cassation on High Judicial Council. In our view, there is prejudice concerning the role of women in society and women as leaders, managers. And one of expression of this prejudice is that no woman is head of a court in Armenia. It is really difficult for women to have authority in men's world full of prejudice. It is necessary to take positive actions to redress the gender imbalance. Achieving equality for women judges in terms of representation at all levels of the judiciary and on policy-making judicial council should be our goal, not only because it is right for women, but also because it is right for the achievement of a more just rule of law. Women judges are strengthening the judiciary. The social ties of men are much more than for women. As the Armenian society is a small one, the ties are real challenging for the independence of justice. So the women judges are perceived more independent. According to the polls, Armenian women judge is more impartial and fair, and the risks for interfering the justice are lower than for men. There are some cases in courts where the parties express their contentment that the judge is a woman. Traditionally, these are family cases, family violence cases, and even labor cases. Indeed, some cases affecting women are better run by women judges. The questions by women judges are perceived differently. During court session, women judges start initiatives that may be different from those started by male judges. We think that several steps must be taken for overcoming the factual gender discrimination in judiciary. First of all, specialized training and dialogues among judges are important to share the challenges faced by women. It will help to promote a greater understanding and commitment to gender equality. We want to highlight the need for continuing judicial education on gender discrimination and educational programs to ensure all members of the judiciary practice gender sensitivity. The next step can be implementation of quotas in each level of judicial instances, which is necessary measure to advance the recruitment and appointment of women judges in all levels of judiciary. Female judicial appointment, particularly at senior levels, can shift gender stereotypes, thereby changing attitudes and perception as to appropriate roles of men and women. And as a result, we won't have such a funny situation which all women judges in Armenia face with. When someone comes to the court and calls to the judge, Mr. Judge. In these cases, I say it is obvious that the judge is not a man. They answer, oh, it is first time I am in court session. I think this is a typical situation showing the influence of stereotyping that the carriers of power and authority must be men. And I hope this will be overcome soon with the active role of women in judiciary and as a chain in all spheres of life. Thank you very much.
Gracias, magistrada Karen Jan.
Thank you, Magistrate. You respected the time. Tentative had to warn you that you were running out of time, so thank you for that. Now, right, we have Ines Mater. She will talk about the access to justice of women in Tunisia. She is now in a very interesting program, supporting the program to reform justice in Tunisia. It is a program funded jointly by the Ministry of Justice of Tunisia and the Union. Thank you, Mr. President. I'd like to begin remarks by thanking the of this conference. Thank you to Cyrus Bill, President of the Association of Women Judges of Tunisia, for her confidence to allow me to talk about this issue. I would like to mention three challenges. The first is administrative justice. I am a judge. And I would like to tell you about this. It's almost 7 p.m. After almost 10 hours listening to different presentations, I'll try to get to the point. Third challenge I have to face is talking about administrative justice, and more specifically, the access of Tunisian women to administrative justice. Being aware, however, of the complexity of this issue, both for specialists of public law and for those who practice private law. I have to say that in Tunisia there are no statistics regarding administrative justice, so my approach will be an empirical one. Mainly when the administrative court from Tunisia has not jurisprudence as such, but extracts of processes and from different years. We published a compilation of processes from 2014. But before mentioning the access of women, I'd like to talk about a general legal framework in our country to understand its specificities that show a certain tension, a tension between the will of emancipation by women and the social conformism nurtured by patriarchal scheme. This tension has an impact on the access of women to administrative justice. The legal framework of women is equal. Somehow it was established with independence in 1956 by negotiating a change after the revolution of January of 2011. There we put an end to an authoritarian regime and we created an enriched legal mechanism. Normally, law crystallized many challenges. Also, the political revolution created a legal revolution that wanted to finish with the French protectorate and abolished monarchy, and also in order to consolidate our society and modernize it. The government undertook a comprehensive reform of the society and made women emancipation a leverage for that momentum. We gave women the right to abort, to travel, to open bank accounts, or to create companies without the authorization of the husband. This was about creating a family planning policy with the right to a non-therapeutical abortion. We built all this around a code, CSP. We wrote a code of disruption with tradition. This was described as state feminism. And even we said that this was a way of taking feminism to the highest level, but always with a patriarchal approach. There are still some issues to be fixed. The only marital address is the address of the husband, and it's also established that conjugal rights of husband have to be respected. So even we have an equalitarian tradition, there are discriminations given the consuetudinary law. Some parts of the society are still nostalgic and they don't want to improve women's situation. Let's talk about the legal framework for women to have access to justice through specific provisions regarding the administrative jurisdiction, and then we will talk about its application, which in general is positive, although there are some limits of gender stereotypes with many different mutations. The first part, a legal framework which is positive for women having access to justice. The access to this administrative justice has different provisions, specific provisions for the administrative jurisdiction that have a goal to facilitate the access to a justice which is still confidential due to the complexity of this contentious administrative jurisdiction. The principle of equality between men and women is guaranteed by the Constitution and by the law. This principle was determined in 1959 in the first constitution of my country. In it, it was established that all citizens had the same rights and duties. They are equal to the law. These principles were consolidated by the Constitution after the revolution in 2014. At the beginning of the Constitution, we can read, "The state will guarantee the supremacy of law, the respect of freedoms, the rights of the man, the independence of the justice, equity, equality, and the equality of rights and duties among all citizens." Constitutional equality for all citizens is also mentioned in different provisions, Article 21, Article 34, among others. But legal protections, the legal protections which are the most important for women appear in Article 46 in this provision of 2014. Here, the state guarantees the rights of women, and it also intends to improve them. The state guarantees equal opportunities for men and women when assuming different responsibilities at all domains. The state will work to achieve parity between men and women and boards and organisms, and will also take necessary measures to eradicate violence against women. This positive mechanism tells us that Tunisia is an atypical country in the Arab Muslim world. Regarding contention administrative jurisdiction, we see also strong laws to make the access to the administrative jurisdiction more affordable. Our court is a constitutional institution established in the first constitution, but it was created on the 1st of January of 1972. The administrative court made the first decision in 1974, in the 3rd of June. The government decree of May that 2017 has allowed a better access to justice. The law of 2017 was intended to improve the access to administrative justice, simplifying the presentation of reports. So this reform has taken into account this imperative and has reinforced the guarantees and rights for defense. These are improvements which are seen at all levels of this administrative jurisdiction. We see that if you can also sue someone by sending a letter, even the lawyer can talk directly to the judges without incurring excessive expenses. This is guaranteed by the gratuity regime, which was established in the law of 1993. And our proceedings should have the best administrative practices. We have a law from 1972 to respect possible contradictions throughout, the contradictory principle throughout the whole instruction. And we can say that the legislator had the clear will to allow an effective access to administrative justice. If we consider that equal access by men and women is a constitutional right, women are the only ones concerned here. Second part, very quickly, implementation of the regulatory framework. If this guarantees equality for all, we have to say, given the reality that the implementation of this regulation framework has different situations. There are historical, sociological and economical factors that don't allow women to have a full access. Administrative justice is very particular given some specific characteristics. The representatives of the nation have benefits and special regimes. That's why they are subjected to specialized trials and judges, and not to common, ordinary judges who have to try to find a balance between the interests of the ruling powers and ordinary citizens. Very often in Tunisia, intimidated citizens didn't want to bring a case to court. They were afraid of not ruling in their favor in case that the defendant or the respondent was the administration. This also has an impact on the social origin of those who have gained access to administrative justice. Normally, these people have a higher educational level who are not so scared of bringing any case to court. This case is difficult to understand, but most of law professionals are shy when they are requested for this kind of processes. Finally, given that the administrative court is in the capital, Tunis, it makes the access to justice more complicated for citizens in a country where roads and railway structures are very deficient. Even creating regional courts, these regional courts won't rule all cases, and even if you can appeal, sending your case by letter, geographical impediments are a barrier. 2 minutes. 1 minute. Okay, 1 minute. Okay. I just like to mention one case of jurisprudence where administrative justice fought against the administration to grant a woman her rights. Through some decisions, the administrative court was fighting against gender stereotypes. On the occasion of an appeal against the Ministry of Finance presented by a woman, she was excluded from the public exam for customs agents. The court fought firmly, and the facts were the following. This young woman passed the exam for customs agent, and when she was doing the practice, a decision to exclude her in a not recent way was notified to her. She asked the Ministry of Finance to give her the reasons of why she had been expelled, and she only received an answer that it was for security reasons. Since that very moment, there was a fight between the Ministry of Finance and the administrative judge to get to know the real reasons for that exclusion. This appeal was a victory of the justice. We saw the document drafted by the police talking about the way of life of that woman, that she had been seen in a hotel accompanied by some foreign people. In 2018, the court cancelled that decision and said that this was sexism. So we see that women can have access to justice, but there are difficulties, of course, coming from other factors, the social and economic evolution, that are actually the ones that could finish with this equal access to justice. Thank you.
Bueno, finalmente.
And now, from Madrid, we have a colleague from the Philippines, Geraldine Feit-Ekon. She's a justice in Sandy Gembajan. She was a chief of the Mediation Center of the Supreme Court. It is curious that mediation gets even to the Supreme Court of the Philippines. She will tell us about institutional violence. Geraldine, thank you very much. You have 12 minutes for this.
Delegation from the Philippines would like to thank the Association of Women Judges in Spain and the International Association of Women Judges. We are glad to be here, and surely and certainly we have learned a lot in the entire session of almost 10 hours listening to several speeches. Allow me to present what is going on in the Philippines. Okay. It's better to be graphic, it's short, and I'd like you to look at the statistics on the screen. If you can look at the numbers, you can see that women in the Philippines earn more than men, and that more women have access to education than men. There are 1.3 women enjoying having the opportunity to go to school for every one man. However, there are more men who have titles over the land than women, and that more men are elected to office than women. That is the current situation in the Philippines. Given that, the ranking of the Philippines in the World Economic Forum on Global Gender Gap Report from 2014 up to 2017 is consistent in the top 10. The Philippines, along with first world countries and high-income countries such as Finland, Norway, Denmark, and Sweden, have always been consistent in the top 10. You could say, therefore, that based on this World Economic Forum Global Gender Gap Index, the Philippines has attained a high educational level for women, health as well as in health and survival. The economic participation of women is also not that bad, given that there are more women who earn more than men. However, we lag in political empowerment. This is the situation in terms of work and economic participation of women in the Philippines. As you can see, although there are areas where there are more men participating or more men working, it is really not that bad. It's like 60-40. In case of the judiciary, right now the Supreme Court has only 20% women, but that used to be 40% and 60% of men. In the third level court or in the appellate courts, the percentage of women is around 35%, while in the first and second level court, it is also of such number. So while there are more men than women right now, definitely the numbers are changing because there are more women who were appointed in the judiciary. While there are more men, we could certainly say that the women who are appointed are much younger and therefore can influence not just the judicial system, but also all aspects of government and the different government agency. This is brought about because of the Philippines' adherence to and adoption of international agreements. So this is the international framework of which the Philippines is working on. Particularly, the Philippines is a signatory to the UN Convention on Elimination of All Forms of Discrimination Against Women. This is a significant agreement because it it considers the international human rights framework that is exclusively devoted to gender equality. CEDAW spells out in detail women's rights to equality and non-discrimination and maps out the range of actions that must be taken to achieve this equality. Also, the Philippines is a party to the Beijing Platform for Action, and this is an agenda for women's empowerment. It aims at accelerating the implementation of the Nairobi forward-looking strategies for the advancement of women and removing all the obstacles to women's active participation in all spheres of public and private life through full and equal share in economic, social, cultural, and political decision-making. The Philippines has also achieved the Millennium Development Goal number 3, which is the promotion of gender equality and empower women. It has been able to eliminate gender disparity in the primary and secondary education, as well as attainment of gender equality in all levels of education in 2015. The Philippines is also part of the Commission on the Status of Women and the ASEAN, or the Association of Southeast Asian Nations Committee on Women, and participate in the Asia-Pacific the APEC, which has a full potential of women's contributions to the Asia-Pacific economy, and which believes that women's contribution remains to be untapped. After the international framework, the Constitution guarantees, the Philippine Constitution guarantees the equality among men and women before the law. And another section of our Constitution is a guarantee that the state shall protect working women by providing safe and healthful working conditions, taking into account their maternal functions and such facilities and opportunities that will enhance their welfare and enable them to realize their full potential. Given the international framework and the national framework in the Constitution, there are several laws that were passed over the years in order to protect women. First is the Women in Development and Nation Building Act. This is a very significant law to the Philippines because this mandates that 5% of the budget of all government agencies should be devoted to women and women development, or what we call as the gender and development. So in all government agencies, 5% of the budget goes to women empowerment. Second is the Magna Carta of Women. This Magna Carta of Women is a broad law which pervades in all areas where women are involved, particularly in their workplace as well as in the exercise of their rights as against the state. We also have the parental leave for solo parents. So women who are separated or when the husband is dead, they can avail of more leave in order to spend more time with their children. Then we have the Anti-Sexual Harassment Act, which is an act that protects women in the workplace. Anti-rape law, before, rape was considered as a crime against chastity, but with the passage of this law, rape is now considered as a crime against a human being, and that a husband can now commit rape if the wife does not want to engage in sexual intercourse. Then we have the Rape Victim Assistance Protection, where the government is mandated to assist women who are victims of rape. We also have the Anti-Trafficking in Persons Act, where the persons, particularly women and children who are trafficked, is protected and given certain privileges once they are rescued from traffickers. As you very well know, the Philippines has a very big trafficking or human trafficking problem, because most of those in the poverty level, particularly women, are trafficked on a daily basis, where some of them are forced to work in prostitution areas or being forced to work as maids in other countries. So we are very big in the campaign against anti-human trafficking, and the law provides that victims who are trafficked will be able to avail of certain services. We also have the Violence Against Women and Their Children Act, where women can seek for protective orders from against the spouse who commits the violence. The party list law is actually not a special law for women, but there is a provision there that says that women can create party lists, and that because it is a vulnerable sector, the women will have a representation in government. Then we have mail-to-order brides. Well, this is a law that prohibits women from prevents men from looking at sites and writing letters so that they can find their wives. Repatriation of Filipinas law. When a Filipina marries a foreigner and she is trapped in another country and she lost her citizenship, under this law, the Filipina can claim and ask for assistance from government so that she can gain back her Philippine citizenship and be allowed to return to the Philippines. Non-discrimination law in the labor code. So before, the women were not allowed to work in night shift duties. Women were not allowed to work after 5. But because of this non-discrimination law, the women are now allowed to work in industries that require to work at night. This is important because the Philippines is known as the call center industry, and most of the call center agents who work at night are women. And because they call to the US and they call to Europe. And if this law is not passed, then it will deprive so many women of the opportunity to work. So this was made a law. Then we have the Comprehensive Agrarian Reform Law, which allowed women to own lands. And again, and last, we have the military training equality, where women were not allowed to join the military and the police, and that these institutions were required to provide facilities solely for women. The Philippine Commission on Women is an agency which is an advisory group to the President in order to help the President in its policy making, and it also coordinates among government agencies on gender equality concerns. By the way, there are no administrative courts in the Philippines. All the executive branches of the executive branch, and where we have the departments, they perform quasi-judicial functions. And the gender policy of all these government or quasi-judicial bodies are under the civil service laws. And the Civil Service Commission of the Philippines has laid down a very strict rule on a committee on decorum and investigation in order to prevent sexual harassment in the workplace, so that there is a quasi-judicial process whenever a woman complains of sexual harassment and the complaint will be investigated, and there is a time frame in the investigation. Again, there are certain leaves and benefits that a woman in the Philippines enjoys. But however, despite those laws, despite adherence to the international law and the Constitution, 1 of every 4 women in the Philippines still suffer gender violence. 1 in every 4 women, despite the laws. Why? Because of structural violence. We believe that the social institutions, particularly the communities in the Philippines, have certain socio-cultural practices, economic situation, the poverty, especially in far-flung areas, poverty that is suffered by women, as well as collective community beliefs, the beliefs of certain tribes, all contribute to this violence, and it is therefore that structural violence, that structural system that must be destroyed in order to have and achieve gender equality. I'm sorry for the lack of time. Thank you.
Muchas gracias, Magistrada Geraldine.
Thank you very much, Geraldine Faith. I think that we have had a long session. We've seen that problems within diverse situations are very serious, but in the closer region and further regions. We could maybe allow 1 or 2 questions. We don't have much time. I think we'd have 1 or 2 questions to finish the day. Is there anybody who wishes to ask a question? Here we have a question. Yes, thank you very much. For Julia Murdoch, I have a question. I'm interested in those sentences that you mentioned of the European Human Rights Court. What I would like to know is the result. What could the court demand of the countries when it is believed that a country has failed to meet its obligations? What happens after that? What can be done? Thank you very much for that question. I'm going to speak in French. Thank you very much for that question. I hope that I understood it correctly. I listened to it in Spanish, but I understand that you're asking about the distribution between the European Rights Court and the subsidiarity principle with the countries, or what message we can give to the member states if we talk about violence against women. Is that your question? I'm sorry, we cannot hear the question being repeated. She's not using a microphone.
Ça, c'est une question. Vous savez très bien que nous, on accorde des dommages.
Yes, well, what's done is that we give compensation to the victims. Obviously, that does not compensate for a rape. But Article 41 establishes this kind of compensation, quite considerable compensation for victims. I think that what really changes the way victims feel is a recognition of the fact that the rape has taken place. That's the most important, and I have seen that in my own country. I've seen that sometimes to fight for 10 years against the system when they get a favourable decision in the European Human Rights Court, this also means that the trial, if it's not considered to be fair, it can be reopened. So there are many things to be taken into account, above all in the European states, with the possibility of reopening that trial and having a fair trial. Those are the three things that we can do by way of remedy. Any other questions? The last one, our colleague from Cameroon.
I would like to ask, one of the speakers said that a husband can be convicted for raping the wife. So I want to ask, how easy or how possible is it for the court to convict a husband, given that at that time when they are in their room, the husband is trying to cajole the wife for sexual intercourse, and maybe the wife does not want to heed to the husband's demand. At that particular time, there are just two of them. And maybe if the husband rapes the wife, they go to court, the wife will say, he raped me, and perhaps the husband will not want to claim responsibility and he will refuse the act. So how then would the court be able to come out with the fact and the conviction that the husband really did the act when the husband does not want to claim that he did it? Thank you.
But surely that with a rape allegation.
Yes.
Any woman who says she has been raped, unless she's very unlucky and there are 7 men in the room, most of the time it's a woman's word against a man's. The fact that the man has a wedding ring on his finger makes it no more or less difficult. And in my country too, since about 1960, a woman can withdraw her consent in marriage. And we do have marital rape convictions. They're not easy, but sometimes the evidence is there, and the judge, the court, the jury, they listen to the two people and they make their minds up.
It's difficult.
Always. It's a hard decision, but being married makes it no harder.
Bien, hemos finalizado. Muchísimas gracias.
We've finished. Thank you very much to all of the speakers, the interpreters, the sign language interpreters, and everybody here for having withstood this marathon day. And tomorrow at 9:15, we will be here once again. See you tomorrow.